Good evening, students. Welcome you all to StudyIQ IAS English. In today's video, we're going to discuss an important judgment delivered by Supreme Court yesterday. In this judgment, Supreme Court has clarified that whether a person who belonged to Hindu community or Sikh or Jain community and who was born in scheduled caste community, whether can such person retain his caste status after conversion to religions such as Islam or Christianity or Judaism. Now, this is very important point of law because on it depends a large number of factors. Because suppose a person was born in Hindu community and that too in scheduled caste community. Now, if such person converts his religion and he becomes Christian or he becomes a Muslim or he becomes a Jew. Now, whether can such person retain all the benefits that has been given to him by law because of his caste status. Now take a look at this video and try to understand whether such person can retain his caste status and the ancillary entitlements or not. See, now this is an important case and this is also important from the point of view of your polity paper. See, conversion of religion to Christianity leads to renunciation of scheduled caste status. Now what happened? In this particular case, there was a person who belonged to Madiga community. He was born into Madiga community, but after certain time, he became Christian. And he also started promoting Christianity and he started working as a Christian pastor. Now, he suffered a certain incident in which several people try to assault him and they also try to insult him by his caste. Now, all of us must understand that people belonging to SC/ST community, for them, law has been created by the name of SC/ST Prevention of Atrocities Act. Now, we all understand that in India, caste system has deep roots. That means even today, there are certain places in which people belonging to SC/ST community, they face discrimination. Not even discrimination, they are also attacked and sometimes severe offenses are committed against them just because of their caste identity. So to protect such people and to remove any sort of discrimination prevalent in society against them, the government in 1989 had enacted SC/ST Prevention of Atrocities Act. So under this act, if any person commits any sort of atrocity against a person belonging to SC/ST community, atrocity could be either whether disparaging a person, insulting a person by his caste name in public, assaulting a person in public just because of his caste identity, making a person do forced work or bonded labor because of his caste identity, trying to grab a land belonging to that person, conducting economic boycott, social boycott of that person, or trying to harass a woman or harassing a woman belonging to SC/ST community even after knowing that she belonged to particular community. Now, all of this act tantamount to atrocities, and any person who commits atrocity is punishable under SC/ST Act. Now, when this particular petitioner before the Supreme Court, when this person was attacked and he was abused just because by his caste name, now this person went to the police station and tried to file an FIR. Police filed an FIR under various provisions of SC/ST Prevention of Atrocities Act. Now a major question rises. By birth, he belonged to SC community. He was a person who belonged to scheduled caste community. He converted his religion. He became a Christian, and for last 1 decade, he was serving as a Christian. He was giving his services as a Christian pastor. Now, if an act is committed against him because of his caste, now can he file an FIR under the provisions of SC/ST Act? That means, does he still retain his caste identity, or because of his conversion, he has lost his caste identity? Now, to find answer to this conundrum, we have to refer to an order by the name of Constitution Scheduled Caste Order 1950. Now this order categorically states who can be a member of scheduled caste, and this order defines scheduled caste member only on the basis of their religion, because as per historical tradition in India, caste system is widely prevalent in Hinduism, or we can say now obviously the caste system is on decline. That means, and caste based discrimination is also on decline, but still there are sporadic incidents in which people are discriminated on the basis of their caste. So recognizing that, the order says that a person who belongs to Hindu religion, only that person can be considered to be a scheduled caste. And now this order was amended in 1956, in which Sikh religion was also added. That means a person who professes Sikh religion. And in 1990, this order was further amended, and people belonging to Buddhist community was also added. That means now effectively this order says that any person who belongs to and who professes Hindu religion, who professes Sikh religion, and who professes Buddhist religion, only such person can be considered to be people belonging to scheduled caste community. Now this is an important order. So now what does this order do? We'll just try to take a pictographic view. A person born into scheduled caste community, if he professes this particular religion, Hinduism, Sikhism, Buddhism, now he retains his caste status, and all the laws and even the constitutional protection that are provided in the favor of scheduled caste community is available to him. Now if a person changes his religion, or he started professing different religion apart from these three religions, now as per this order, his caste status is revoked. His caste status is revoked, and all the entitlements or benefits that were available to him because he belonged to scheduled caste community, now such benefits will no more be available to him. Now, what important point of law is, what do we mean by profession? Because Supreme Court has tried to interpret this word, because the order simply says a person who professes Sikh religion, Hindu religion, or Buddhist religion. Court simply stated in this particular case, profession of religion is different from freedom of conscience. Profession of religion generally means that a person must outward manifest his religious beliefs. When you declare your particular religious belief, or when you perform any sort of activities, when you perform any sort of outside activities by which people get to know about your religion. For example, if a person is performing worship, or if a person is performing namaz, or if a person is performing any sort of religious activity, what he is trying to do, he is professing his religion. So profession of religion means outward manifestation of religious beliefs. So when a person manifests his religious beliefs in an outward manner, either by doing any religious practice or by indulging in any sort of practice that obviously he believes in, so that is called as profession. Court said profession of religion does not mean the internal belief system of a person, that is conscience. So if a person try to follow his religious practices, if a person performs the religious practices, now he is transforming his internal belief into outside manifestation, and that is what is precisely called as profession of religion. Now what happened in this particular case? The petitioner Chintada Anand, now he had become Christian, or he had adopted Christianity. One, so he was delivering his services to church. He was also participating in Christian religious gatherings, as well as he was obviously practicing as a Christian. Now what happened when he filed this petition? The other parties tried to challenge his petition. They stated that as he has adopted Christianity, he has relinquished Hinduism. So that means because of that, his caste status, his scheduled caste status is also gone. Now he cannot file an FIR under SC/ST Prevention of Atrocity Act, because such act allows only scheduled caste and scheduled tribes member to file an FIR, because that was made precisely for their benefit. Now this is an important point of law that the court had to decide. Now what did court said? What did court say? Court simply stated, first, court stated in Christianity there is no construct called as religion. There is no construct called as religion. The court tried to take guidance from Bible. The court stated, it is clearly stated in New Testament. It is clearly stated in New Testament that, and the court quotes the New Testament. Court says that there is neither Jew nor Gentile, neither slave nor free, nor is there male and female, for you are all one in Christ Jesus. The court simply stated in this particular verse, the Bible is saying that you are above all of your identities. You are above all of your identities. So by looking at this particular statement from New Testament, there is a clear depiction that Christianity does not believe in caste. The court said, given Christianity does not believe in caste, so that's why if a person adopts Christianity, or if a person start following Christianity, he start professing Christianity, so he leaves his caste identity. He leaves his caste identity, he shuns his caste identity. So his caste identity is relinquished forever. So because of that, court said, and as per Constitution, Scheduled Caste Order 1950, any person professing Hinduism, Buddhism and Sikhism, only such person can claim to be persons of or members of scheduled caste community. So as soon as a person who has relinquished his religion, he has adopted another religion, so he loses his caste status. So the court categorically stated, see, the court said the persons who did not profess any of the three religions, Hinduism, Buddhism and Sikhism, mentioned in clause 3 of 1950 order, they cannot avail any statutory benefit, protection, reservation or entitlement of scheduled caste members. So the court has tried to clear this distinction. The court has tried to clear the fog over this particular matter, that if a person belonging to these three religions, if he converts himself into any other religion, he loses his caste status, and because of that, all the entitlements, all the benefits including reservation, now he cannot claim to avail, he cannot claim to take benefits of all of these entitlements and benefits. The court has clearly stated that even a person who reconverts, so suppose now there was a person who was a Hindu or Sikh or a Jain and he belonged to scheduled caste community. Now he converted himself to any other religion, and now he also reconverted himself. As he reconverted himself, now can he claim the benefits of scheduled caste community or the entitlements or the reservation benefits available to them? The court has stated, first, to claim such benefit or to reclaim such benefit, first of all he has to prove his caste identity before conversion. So he has to categorically prove before the court that what was his caste identity before conversion. One. Secondly, he also has to submit evidences, impeccable and unimpeachable evidences, to show that he has returned to his original religion and he has started professing his original religion too. And thirdly, he also has to prove before the court that the members of his original caste have accepted and assimilated him into the community. So the court said, just by proving these three things, a person can be readmitted into the original community and he can reclaim the benefits that he once claimed because of being a member of scheduled caste community. So now the court has cleared the fog, clearly stated that only persons belonging to Hinduism, only persons professing Hinduism, Sikhism or Buddhism, they can claim to be a member of scheduled caste. They can also claim to avail the benefits that are available to scheduled caste members as per law. And if a person converts to any other religion apart from the religion, the person loses his caste status as well as all of the benefits or entitlements that he was entitled to before conversion. And if he reconverts himself to his original religion, he has to prove in a court of law through substantial evidences that he has to prove his caste identity. One. Secondly, he has to prove that he has reconverted, he has started professing the original religion, and thirdly, that the members of his community have admitted him into the original religion. So this was all about today's video. So we have tried to cover important point of law. It is also important from the perspective of GS. It is also important from the perspective of if ever a question comes where they try to ask you how to balance freedom of religion with the constitutional protections provided to specific communities. Because at one hand, this law is saying, or we can say the judgment is saying, see, this is the friction zone. Because on one hand, Constitution of India is providing freedom of religion. On the other hand, the scheduled caste, the Constitution Scheduled Caste 1950 order, it is specifically saying if a person changes the religion, all the benefits and entitlements that he was entitled to, they are taken away. Now there is a friction between both of these rights. So you can be asked, the UPSC can ask you and it can ask you to analyze the different aspects or the different facets of this particular topic. So you have to try to balance both of these facets. You have to try to balance that, yes, a person still have a freedom of religion, but if certain benefits were given to certain communities because the communities face historical disadvantage and because of the conversion of religion, If because of religious conversion, a person shuns his caste identity, so obviously when he is not facing or when he is not subject to the same discrimination, obviously the entitlements that were available to him are also taken away. So this is how you can approach your question. This is how you can write down your answers. And with this, we'll finish today's video, and we'll try to bring certain or some more of some videos so as to guide you on different facets of law as well as Indian polity. That's all for today. Thank you. Goodbye. Jai Hind.